welcome, Chair Abler.
Well, thank you, Mr. Chair.
And to your bill.
There you go. Yeah, it's. I'd like to move Senate File 446, and it's going to be laid over because there's some costs. This is a simple little bill. Bingo. Anyway, it's just has to do with the ability of counties to actually pay for the services they provide, and I'm going to leave it at that. I have a testifier who can go into more detail about that. But before we do there, I'd like to move an effective date, Mr. Chair, if I can move the A1 amendment.
Yes. Members, Senator Abler moves the A1 amendment. You all see that it's just adding the effective date at the end of the bill. So all those in favor of the A1 amendment, please say aye. 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 Opposed?
Thank
Passes
you.
to your bill.
Well, thank you. And I'll just to make it cleaner, I'll just let Mr. Thiel describe the whole thing. So,
welcome to the committee, and please identify yourself for the record and continue with your testimony.
Thank you very much, Mr. Chair. My name is Brad Thiel. I'm the Economic Assistance Director for Anoka County, and I'm here in support of Senate File 446. And I'll explain a little bit how we got here. So there's a federal law change in 2018 that increased the annual child support collection fee from $25 to $35 per family for cases that have never been opened on public assistance. The previous statute set the fee at $25 after $500 was collected. The new federal statute sets the fee at $35 after $550 is collected. So currently Minnesota would be out of federal compliance by collecting $25 after the $500 is collected. The Minnesota statute needs to match the federal law to prevent the loss of approximately $500,000 in statewide revenue annually, as Minnesota would need to send the federal child support program $10 for every qualifying case, and the $10 would be paid by the counties. The proposed language in the bill would align Minnesota statute with the federal statute, allowing the child support program to keep the money in Minnesota to pay for the services that we're providing. The funding is crucial to counties in their operation of the federally mandated state delegated child support program. And then Senator Abel already put in the effective date, and this legislation is supported by the Minnesota Association of Social Service Administrators, MAXA, and also the Minnesota Family Support and Recovery Council, MFSRC, which is a group of child support professionals. So they've looked at this as well, and so those two organizations support it as well. So I appreciate your support.
Okay. Thank you, Mr. Thiel. Senator Abler.
Thank you, Mr. Chair. And I'm just always amazed at the level of arcane detail the feds go through to tell us how to run our state. And why they care about $10 here and there just ceases to amaze me. But anyway, so that's the bill, and there is a small fiscal note we expect based upon telling people about this new fee, and so the bill cannot move forward. Although the bill is fiscally neutral in its own phase, there's some small costs we expect, so we'll wait on that to advance the bill at some later time.
Okay, thank you, Senator Abler. Members, it is a simple bill, but any questions for Senator Abler, the testifier? Yes, Senator Kiffmeyer.
Thank you, Mr. Chair. Senator Abler, I serve on the Child Support Task Force. I have for 2 years. So when I hear this is not a subject that I recall coming before our Child Support Task Force, and we do have members as well on the committee, a whole variety of members. So this annual fee for child support collection. So have you talked to the Child Support Task Force or anything like that in regards to this bill? I don't recall it, but maybe you have.
Mr. Thiel?
Mr. Chair, Senator Kiffmeyer, we have had discussions with DHS, specifically the Child Support Division, about this bill and the need for it for us to align the Minnesota statute with the federal statute. We did discuss it last year, so not specifically to the task force. I'm not aware of that. And this came about too late for us to, generate or propose a bill last year. So I don't know if that answers your question, but I haven't had a discussion with the Child Support Task Force, but I have with Child Support Division within DHS.
Right. Well, thank you, Mr. Chairman. Sorry. Yes, the DHS does staff and do support. I would have expected them to have brought this before the child support. And when you're increasing a fee, when you say this came about too late, or just recently. You're just raising a fee. So could you explain again the federal law that I understand this is tied to, that you're either trying to comply with or not quite sure? Could you explain that in a little more detail?
Yeah, Mr. Thiel, and as you're doing that, we see some people from DHS maybe conferring on this too, so we may have somebody joining you too, but at this point, Mr. Thiel?
Mr. Chair, Senator Kiffmeyer, this came about approximately February of 2018 as part of the tax bill at the federal level. And then we noticed that the fee had changed as part of that. And so it was later in, I guess after this legislative session had started last year, so we weren't able to get our groups together to propose a bill. So the federal fee increased to $35 from $25 after $550 is collected. So that's the federal change. The Minnesota statute reads $25. The fee is $25 after $500 is collected. That's where the controversy, or the difference occurs. So we're asking for the Minnesota statute to match the federal statute so that that revenue can remain in Minnesota.
Senator Kiffmeyer?
Well, thank you. Thank you, Mr. Chair. Yes, well, I still don't quite fully have a sense of this. And the other question is, if this is done under the federal level, do they mandate that you increase? I mean, is that something, or is it permissive that you can make your fee match the feds?
Mr. Thiel?
Mr. Chair, Senator Kiffmeyer, I guess I'm not sure how to answer it. I think if the statutes don't align, that's when we risk the loss of revenues remaining in Minnesota. So if the statutes don't align, as I understand it, and maybe there's somebody else here from DHS that can be more articulate about it, then we will be obligated to send, meaning the state is obligated to send money back to the federal government, which then would reduce the amount of revenue we would collect and use for our program. So if we don't change it, then the counties will lose revenue in a big amount.
So, Mr. Chair, yes.
Would the department like to weigh in? I think you're coming up to the mic. So please state your name for the record and continue with your testimony.
Thank you, Mr. Chair. My name is Jennifer Sommerfeld. I'm the Legislative Director for Children and Family Services. The way the federal law works, Senator Kiffmeyer, is that the state is required to remit $35 in all cases that meet that threshold. How we collect that money is permissive. We can pass it along to the folks who are getting the services, or the state can make up the money and pay that to the feds, if that makes sense. So regardless of what our law says, we have to pay that fee to the federal government.
Okay.
Senator Kiffmeyer?
Yeah, thank you. So what I'm seeing here then, the current amount is 25. The feds moved it up to 35 if we don't move ours up to 35. And then this fee is paid for by the individuals according to Minnesota state law. So this is where the state is not picking up. It is paid for by the individuals. And I just want to reaffirm again, my understanding then is this $35, all of it stays in the state of Minnesota and goes to the county then?
Ms. Sommerfeld?
Mr. Chair, Senator Kiffmeyer, some of it does go to the federal level. We return some of that money. That's required. That's why we're required to collect that fee. Some of that goes back to the federal government, and then there's a portion called the non-federal share that stays here, and that goes to the counties.
Senator Kiffmeyer?
And how much money currently goes back to the feds?
I don't know that I have that number with me.
Okay, well.
We will have to get back to you on that.
All right. Mr. Chair, I think I have a better understanding, which kind of helps me in regards to this bill, but let me just think about this a minute.
And Mr. Chair?
Senator Abler.
Just for members' benefit, we should not have called this a simple little bill. That was a mistake on my part, sorry. But this is going to come back. So this is going to be laid over, and we'll see what the department says we're going to be charged to implement this, because they have to do some publication and postings and so on. And so we'll have ample time to see if we want to do this or not.
So we have another question here.
Mr. Chair,
Senator Benson.
Not to belabor the point, and it's not even a specific question. I understand that we need to raise it because the feds want a certain amount of money. I get that, but I'm looking at page 2, line 16. There's a $25 fee. Is that the same fee or a different fee? It relates to overdue support owed on behalf of a person not receiving public assistance. I'm not asking to increase the fee. I just want to make sure we're not missing something in the process. And it doesn't need to be solved today. But if the fee on the front page is the same as the fee on the second page, it's just a different category person, do we need the $35 there? I don't need an answer. I need somebody who knows to tell me that we didn't overlook that.
If somebody wants this, Ms. Sommerfeld, do you want to tackle that, or do you something you want to get back to us on?
Yes, Mr. Chair. Senator Benson, that is the fee for the tax intercept, so that it's a separate fee.
Thank you, Mr. Chair.
Members, any other questions? Anything? Any final words, Senator Abler?
I just soon lay the bill over and move on to the next one, Mr. Chair. So.
Okay. Senate File 446 will be laid over.
Thank you, Mr. Chair and members. Thank you.
Thank you.
Oh, Senator Champion, no, we're doing Senator Eakin first. Yours is probably longer. We wanted to reserve time for that, if that's okay.
It's okay. I saw this motion right here, and that.
Oh, I
call for me to go.
I apologize. His is a
See,
simple
now,
little
next
bill,
time, if you
too.
don't want me to come up, just do this right here.
Okay.
Okay? That's what I want.
Sorry, I apologize. Senator Eakin, I'm sorry. So easy playoff game, simple little bill. Senator Eakin, is this a simple little bill?
Yes, Mr. Chair, this is a simple little bill, so I hope simpler than yours.
So Senator Isaacson will move Senate File 454 to be in front of them.
And
Mr. Chair, I gleefully move the bill
gleefully.
forward. Thank you. Yes, gleefully.
Could that be in the, thank you, it's the gleeful little bill. Senator Eakin, welcome to the committee, and you have an amendment?
thank you, Mr. Chair. I do have an A1 amendment if to put the bill in the shape and form that I would like.
If you could just describe briefly what it does, just because people are listening at home. They may not have this in front of them. So.
Sure. Well, it's really just technical changes, I guess, to make the language conform to, and I received assistance from both the Bureau of Criminal Apprehension and the Department of Human Services in getting the language right. So it doesn't change at all the substance of the bill.
Okay.
It just simply puts it in the right language form.
Does Senator Klein want to enthusiastically offer this amendment, perhaps?
I offer the A1.
Thank you. So the A1's been moved. Everybody understand it? All in favor, say aye. Aye. Opposed? Senator Eakin, to your bill.
Great. Well, thank you, Mr. Chair and members. In this bill, what it does in effect is it requires a national background check to be conducted for those who work in home and community-based services. The reason that I brought this bill forward is because of a problem that occurred up in Detroit Lakes, which is in my district. There was a case of a group home worker who had sexually assaulted one of the residents, and there was a background study that was done, and the director of the group homes there was saying that they did not believe that there was any reason. As a matter of fact, he said, quote, we had done a background study prior to their employment, and they passed the background study. We had no information to believe there was an issue with them. And actually, there were two individuals that were involved in two separate cases. But the one individual they discovered later, one of the law enforcement officers that was conducting the investigation discovered that, in fact, one of the individuals did have a record and had committed a similar crime in another state. But the background studies that we do in Minnesota for home and community-based services only applies to criminal activity that occurred within the state of Minnesota. We all know that people move a great deal, and that there may be problems that occur in other states. So we felt that, especially in dealing with our most vulnerable population, that we need to make sure that we do a national background study. And that's what this bill accomplishes. It requires that we do a national background study to ensure that we're doing our most thorough job possible in vetting these potential employees who are working with these vulnerable adults. So that's the gist of the bill, and I do have with me today also Patrick Carter, who is from the Department of Human Services, works in the background studies division there. And I have Katie Engler, who is with the Bureau of Criminal Apprehension, that can help answer questions about the specifics of the bill as well.
Well, thank you. So you suggest we go to questions, and they can just be your phone or friend people.
Right.
Mr. Carter, don't we already do these national background checks as part of the expanded background studies that we do?
Mr. Chair, members, Patrick Carter from DHS Office of Inspector General. We at DHS conduct background studies for about 60 different provider types, and each of those provider types have different requirements for the databases that we look at. The provider type that we're talking about here, home and community-based services, right now the default study for these programs is a state-based fingerprint check. Based on legislation that passed last session, there was a change to the reasonable cause standard to require an FBI check. So for any individual who has lived outside the state sometime in the last 5 years, they would be required to have a fingerprint-based FBI check. But that would not be required for all individuals in home and community-based services, as would be required under this bill.
Now, Mr. Carter, that's really interesting. I somehow thought we were moving to a more uniform thing, and when you have nothing else to do, there must be some kind of table that shows who gets what kind of background check. I think the committee would be interested in that, and that might be interesting for the next stop that you're going to,
Right.
Senator, because you're going to Judiciary.
Right. And Mr. Chair, I had thought about that there's probably other areas where we should maybe be doing these national background checks as well. But for sure, I thought the home and community-based services, because of how vulnerable the population is there.
Yeah, and there's no disagreement there. So, Mr. Carter, this Net Study 2.0 thing, is that not for these folks? Or just in short, I don't want to belabor it here, but it's not about this bill, but go ahead.
Mr. Chair, home and community-based service providers use Net Study 2.0. It's the system that they use to submit the fingerprint-based state studies, but it doesn't automatically require an FBI check. That varies by program type. So some programs use Net Study and they require FBI checks for all studies. Others require state-based studies by default.
That's really interesting. Senator Ralph.
Thank you, Mr. Chair. I was just reading the handout that was involved about the incident that was involved, and as I understand it, both of the crimes were committed within the state of Minnesota. So I guess my question is, if we're not picking up stuff in the state, why would that be in a national database? I mean, I'm not arguing with the reason to have a national database check. I'm wondering why, if in this instance we are suddenly doing a national background check because we missed it in a state background check. So I guess I'd like some information on, if you have it, on what happened there.
Oh.
Mr. Carter or Ms. Engler, whichever, or Senator.
Yeah, Mr. Chair and Senator Ralph, one of the individuals that was involved did have a prior crime record in another state that was not picked up before they were hired at this group home. So they committed the crime in Minnesota after they'd committed the crime, and I believe the state was Pennsylvania, where they had committed this other crime, and it was not picked up as a result. The article doesn't refer to that, because the article was written prior to the discovery of this other crime that had occurred previously.
Okay.
Yep.
Senator Ruff. Thank you, Mr. Chair. Senator Benson.
Thank you, Mr. Chair. I'm sorry, this is quite disturbing. Sorry, so I'm going to save that for reading at home. I'm looking at, on the A1 amendment, starting on line 1.27, actually the whole subdivision 3, I see the new language, except when specifically required by law. So the entity, we updated that language. If the commissioner conducts a national criminal record check when required by law and exclusively uses the relevant information to make a disqualification, the data is private and can't be shared, and the license holder is not required to obtain a copy of the disqualification letter. Could you walk me through why that couldn't be shared with a county agency? Maybe I'm reading something wrong. Maybe there's like a double negative in here somewhere. Why are we keeping this private if they found something? So
Whichever one of the panel would like to respond to that.
So, well, and Mr. Chair and Senator Benson, as I understand it, as far as the FBI investigative information is concerned, that can only be shared with the department and with the state, and it's the federal government that does not allow it to be disseminated or shared with anybody else. The individual involved who is the subject of the investigation can get that information from the FBI or from the state, from the department as well, I believe. But it cannot, and they can share it with whoever they want, but the state itself cannot share it with anybody except for the individual who's the subject of that investigation. And when they're making a determination in the investigation as to whether they're qualified or should be allowed to work in one of these facilities, the state can give a thumbs down if there is criminal activity, but they can't say why.
Thank you, Mr. Chair. As you were walking through that, they can say the individual is disqualified without going into detail. And so I understand that, but then that individual will be tagged as disqualified by all these other entities who might be looking at hiring the person. Is that a correct understanding, Mr. Chair, Senator?
Sure.
Mr. Carter?
Mr. Chair, Senator Benson, in general, you're correct that if an individual is disqualified or we find disqualifying information, they would be disqualified from other DHS programs for which they've been required to have a DHS study.
Okay, thank you, Mr. Chair.
And so if the subject didn't bother to ask, he would never know or she would never know why they were disqualified, just that they were. Is that right?
Mr. Chair, when an individual is disqualified, the state law requires that we provide in their disqualification letter the reasons for which they're disqualified. So they would have the information, the basis for which we're making our disqualifying determination and information on how they can request reconsideration or appeal that information.
But it says we know you're a rapist and you can't take this job. Is it as specific as that?
Mr. Chair, the information that's included usually specifies the crime, the date of the conviction, the county that it occurred in. So it's fairly specific information.
Ms. Engler, do you want to comment? You come all this way to sit there and smile.
Mr. Chair, Katie Engler with the Bureau of Criminal Apprehension. I'm just here to answer any questions you have about the actual mechanics of how the data from the FBI are retrieved.
All right. Other questions from members? Senator Kiffmeyer.
Thank you, Mr. Chair. And so the question I have is, since in this particular case, in this article, the crime that was committed in another state, how was that picked up, the crime in another state, when you're doing the regular background check and the things that are in current law already? Would that have been picked up, and how would they have picked it up in regards to, like you're mentioning in the story, he had this other conviction, but didn't know it at the time he was hired because it was out of state. So how are you changing this law in such a way that in a situation, again, where the owner of one of these places wants to do this background check, what has changed to make it possible to get at a violation outside the state of Minnesota?
Senator?
Yeah, and Mr. Chair and Senator Kiffmeyer, I know that the thing that's changed now is that they're doing fingerprint checks where they had previously been doing just name checks, as I understand it, prior to the
name and date.
But we are doing fingerprints now. And the FBI files are based on fingerprints. And so it might be a case where we're kind of catching up with the new technology now, which enables us to now tap into that national database.
Senator Kiffmeyer.
No, I think that answers it. That's what I was trying to get at, but I wasn't hearing it explicitly, and I couldn't exactly read through all the if this and if that in this section of law. I couldn't quite get it clear. So it's mainly the fingerprint that's going to help them to catch it. And by the way, Mr. Chair, I just want to say probably for home and community-based services, this is particularly important because there's often a small group of people alone and have a lot of privacy and a lot of situations where this is very important, I think, to make sure that they have that, especially with these kinds of people. So I think I appreciate that. Thank you.
So, Ms. Engler, you could actually ditch if you want. I have another person wants to testify, so you can escape while the getting is good if you like. We may invite you back if you want to raise your hand. There's something we need to hear from you. Mr. Griffin, welcome to the committee.
Thank you, Mr. Chairman, members. Representative Eakin, we are in support of the bill, and I should say that I am Phil Griffin representing ARM today. But we did have one concern that we wanted to raise on the amendment at lines 2.17. We have a blank appropriation. While we know that there are costs associated with doing these background checks, we want to work with the author and the department as we move forward to make sure that as those costs are passed on to our members that they aren't exorbitant, and we keep them as reasonable as possible. But we understand the importance of this issue and strongly support the intent behind the legislation.
Senator Eakin, it is good, so good to have you in the committee. When you get through judiciary, you get to come visit us again, and we'll talk about the money. So,
Sure.
Mr. Griffin, that'll be a discussion. Is anybody else in the audience have especially a concern, comment about this?
Thank you, Mr. Chairman, members.
Yeah, thank you very much. Questions, comments? Simple little bill, 13 minutes. With that, Senator Isaacson renews his motion that he gleefully send this. That is gleefully sending it to judiciary. There's two jokes there. As amended, everybody understand the motion? All in favor, say aye. Aye. Opposed? Thank you.
Great.
We'll
Thank
see you
you,
again.
Mr. Chair. Thank you,
Mr.
members.
Carter, Ms. Engler. Senator Champion, welcome to the committee. And Senator Hoffman, do you have some level of enthusiasm about this bill? You want to, I see actually Senator Hayden's a co-author here, so I'll just offer Senator Hayden a chance to move this.
I'd like to move the bill.
Thank you.
Mr. Chair.
Welcome to the committee.
Thank you, Mr. Chair, for allowing me to present Senate File 342. I would like to start by saying that there is an A1 amendment that would get the bill in the shape that I would like, but I could give a brief overview, and I'd like to start at the back first and then come forward, because there are two components to this bill. One is the first section talks about disqualifications and background checks under 245C, but the latter part of the bill talks about or covers the reestablishment of parental rights under 260C, .329. So I'd like to take the latter first, if I might.
Please.
So currently, Mr. Chair, just to put all this in context, I'm thankful for you all around the table, and also Senator Rosen, who I know have done some wonderful work around child protection, because these issues are important to us, along with Senator Hayden and the others. Currently, in the statute, under Minnesota Statute 260C .329, it says that parental rights can be reestablished if there's a petition that is brought forward only by the county attorney, and is only in situations where there's non-egregious harm, which means there's no physical abuse or anything of that nature. Now, it also says that the only children that would be eligible for reestablishment of parental rights if a petition is brought by the county attorney is a child that is at least 15 years of age. What I am attempting to do here is to modify that law based on my experience and my discussions with a cross-section of people. And just so you know, I have had extensive conversations with a number of people and organizations, and I will continue to do so, because there's some places where we find common ground and some things that need to be discussed a little more. So let me tell you what I would like to do, and you'll also see this highlighted in the A1 amendment. The first thing that I'd like to do is that I believe that the county attorney's office should not be the only individual or the only person who can file a petition to reestablish parental rights. The reason why I believe that's important is because I know that county attorneys are nice people, but they have their own opinion, and the person that is the decision maker in any court proceeding is a judge. And a judge hears all the information, from the county attorney to private attorneys to witnesses, and they make a decision and a determination about what should happen around reestablishment of parental rights. I don't think that the county attorney's office should be the judge only to say, no, I don't think that this should happen. So I want to make sure that a parent who may have suffered from, and some people ask the question, who are the parents usually this would cover? Really, individuals who struggle with mental health issues or chemical dependency issues, because it takes sometimes a longer time for them to be able to do the things that one would be concerned about and address those needs. So I think that a parent should be able to file a petition. Secondly, the petition, as you'll see in the A1 amendment, goes through a number of different things, because I asked that just like an expungement petition, when you file for an expungement, it goes through a litany of questions like, what was the issue? What date was it? You know, what have you done since that time to rehabilitate yourself? Did you address the underlying, all those things? And I think that this bill does something that the current law doesn't do, which is to articulate with clarity, or as much as possible, what a parent would have to demonstrate and show in the petition that is going to be submitted to the court and also served upon all the parties, all the interested parties. Like, for an example, it says the petitioner's relationship to each child for whom reunification is sought, the details of termination of the parental rights for which unification is sought, what steps the petitioner has taken towards personal rehabilitation since the time of the order. That's important, right? Because you want to make sure that if someone's gone to treatment, they can show that. If they've done all these important things, that would be important. So that petition, although what's articulated there as the contents of the petition is not exhaustive, we're always open to if there's something else that should be there. That petition would then have to be served upon the county attorney's office, the guardian ad litem, and others. Now, one would say, well, how would you know who the guardian ad litem is? Is because when there's a TPR, which is a termination of parental rights case, once that has been exhausted, and if there's voluntary or involuntary termination, until a child is adopted, they are in foster care, and there is an assigned guardian ad litem who is with their child, regardless of the age. 6, 7, 10, 14, there's a guardian. So I believe that the county agency has to be served, the county attorney should be served, and also the guardian ad litem. And the reason for that is because the petition notifies them that here is this petition, here's what the person has done, and they can then react to it one way or the other. They can show up, they can be a part of the proceedings, because this is all information that the court needs in order to make a determination as to whether a parent's rights should be reconnected. Here's the other important issue. A child who is in the midst of being adopted is not eligible. So there's already 2 years that has to go by, and then the child that is the subject of the petition, if someone is actively going through the process of an adoption agreement or whatever, that child's not eligible. So the parent cannot reestablish those rights. Why do I believe that to be important? Is because this is to make sure that children are not languishing in foster care if there's the possibility of reunifying a family. We want to make sure that we honor the process itself, and so that's why that's there. So the petition is articulated with clarity, is served upon all the parties, then they all can come at an appointed time in order to be heard. Now, the parent under my bill is not given a public defender. I'm not looking to put any additional burden on the public defender's office. This is something that a parent would have to do in order to demonstrate or show that this is how important it is to them. Filing fee is there, but can be waived if they complete what they call an informal papyrus, which is something they submit to the court to say, I can't afford to pay the filing fee. So there you have it. Now, the age of the child, like you'll hear a lot from some people that says, okay, the current law says 15 years old. Others are going to say, well, we think it should be, kids at least 10. I don't have an age. The reason why I don't have an age is because I think age is an arbitrary notion that should not be a barrier as to whether a parent can put forth a petition or the county attorney to put forth a petition in order to say that this family should be reunified or not. And folks are different. But we still have the guardian ad litem and others who can speak to whether this would be appropriate or not. Do not be confused with the CHIPS proceedings or a proceeding for termination of parental rights. Some people say, well, hey, a child is entitled to an attorney, if they're at least 10 years of age in the child protection system, so they should be entitled to an attorney here. I don't make that argument because in a child protection case, as you know, if the child is 10 years of age or older, they will have an attorney, but the guardian ad litem is to speak to all these important issues, so the guardian ad litem is already in place, and the voice of the child and the objectivity of the matter will be dealt with. And so when you think in terms of the A1 amendment, it just articulates with clarity everything that I just said, and then so maybe I'll pause there just for a second and see if there are any questions about that portion, because the expungement portion is a different portion.
Well, I appreciate bringing this forward. Questions from members at this point? Senator Klein.
Mr. Chair, Senator Champion, you mentioned that there would be no ability to petition on the part of the parent if adoption is being pursued. Can you direct me to the point in the amendment or in the proposed bill where that language?
Yes. Just give me one moment. If you go to, Mr. Chair?
Yeah, please.
Senator Klein, if you go to the main bill itself, page 6, if you look at line 6.4, and of course it says, a petition for reestablishment of the legal parent and child relationship may be filed when, and it goes through those things. And it says, but the child is not the subject of a written adoption placement agreement between the responsible social service agency and the prospective adoptive parents as required under the rules. So a child who is the subject of a proceeding for adoption would not be eligible for the reestablishment of parental rights.
Senator Klein.
Mr. Chair, Senator Champion, thank you for doing my homework for me there. I appreciate that. And you're right, it is in the proposal as you described. And as it's my understanding that the county attorneys have concerns with this proposition. Can you speak to that, or are the county attorneys here?
So I would speak to it, but
Champion,
they are definitely in the room and they can speak to that as well. The county attorney has a group that deals with this subject area, the juvenile law area. And the last time there was an agreement, which is the current law that you see now, was in 2013, or 2012, 2013, from my understanding. So one of the concerns that they have is allowing a parent to be able to petition the court. And the second concern that they've talked about has been the age. They believe it should be only for older children. There's been some discussion about whether that could potentially go down to 10. So it's my understanding those are the places, probably amongst other things, that they have the biggest challenge around.
Senator Klein.
That's a good explanation. Would there be the possibility to question the county attorneys on this?
Oh, assuming, when the time comes. Let's get this, we'll give you ample time. And I think when this goes to the judiciary, you could just want to go watch that lawyer frenzy there, and they'll have all kinds of them there. So let's, Senator Benson.
Mr. Chair, to the adoption point, as we go through the foster care system, there's a point when adoption starts to be considered. And how does this impact that decision point? So if there's and I don't remember the time frame that's immediately before an official adoption petition is filed, but could this be used to extend foster care for those children who would have been eligible for adoption? So not to interrupt something that's already started, but we know there's some pre-qualification, background checks, et cetera. I don't know if you're prepared to answer that because it is a little outside this bill, but I'd like to at least have it addressed.
Senator Champion.
Mr. Chair, Senator Benson, so the first thing that I'll say, under this bill, there has to be at least 2 years before a parent can even seek to reestablish parental rights. Number two, it's my understanding that younger kids have a better chance of being adopted 6 years or under. As it pertains to your question of considered, I'm not certain what that means. It's my understanding that that's a part of the process, the adoption agreement proceeding is that we're going to do these things. So it's my understanding that it would already be covered, but I would be interested in hearing if someone else has a different perspective. But it's my understanding that the agreement is a part of the process, and a part of that agreement means the background studies and checks and all that other stuff.
Senator Benson.
Thank you, Mr. Chair. I'll have to do some work on my own. I'm a little concerned about extending children in foster care. I support particularly fathers who have been separated from their children. We know that it makes a significant difference in a child's life to have a parent re-engage with them. My concern, we're changing the age. I see the amendment did bring county attorneys back in, so we aren't completely disregarding them. I do have some questions about how this impacts the foster care system, particularly those children who are on a path to permanency in the foster care system. And so I need to get a little more, and you might have nailed it exactly. I just know that there are specific decision points that are made, the emergency foster care and so forth. So, Mr. Chair, I'm hoping that, I don't know if this has a fiscal note. Is this coming back to us at some point?
We don't believe there's a fiscal impact to us.
There's no fiscal impact.
So it would not normally come back here.
Okay, I might have some more questions because I've been reading and I pulled out my statute books trying to see what we're doing here, but I might have more questions. Thank you.
And so eventually we're going to put the bill in order. There's two people that have asked to testify, including a county attorney. So that there'll be, it's good we allowed ample time for this. Any questions? Actually, Senator Hayden, go ahead.
Well, thank you, Mr. Chair, and thank you, Senator Champion, for bringing this important provision in your bill. Just by way of, and I know that you practice a little bit of this and work inside of the system, can you give us some sense of how often a county attorney petitions on behalf of the parent for reinstatement of their parental rights?
Senator Champion.
Thank you, Mr. Chair. Senator Hayden, I asked that question, and it's my understanding 0.
Senator Hayden.
So, Mr. Chair and Senator Champion, thank you for that, because I thought I'd heard that too. And members, I think that is one of the important stats here, is that there are often, we talk in this committee a lot about rehabilitation, and we've spent a lot of time with substance use disorders or chemical dependency and the pathway for people to rehabilitate themselves and get on their way with their lives. Sometimes, a lot of times, and in the work that Senator Rosen has been doing, even on the opioid steward bill, it is the child protection issues that happen with that, and we wanted to divert, or we want to make sure some of the money, if that bill is successful, gets into that system. I think where Senator Champion is kind of highlighting for us is when that actually happens. A person rehabilitates themselves, they are back on track, and because of their addiction or substance use at the time, they lost their children, and now they're asking the court to see if it would be feasible, based on all of the long criteria that Senator Champion has put forth, if they could reestablish their parental relationship, and then the judge would have to do that. So I don't think that this bill actually does that, but it does happen to do that. And today, for whatever reason, and the county attorneys are here, or the folks representing them, that process hasn't been happening. And so I think that we have children who have not been adopted because maybe they're older or maybe whatever, have not been adopted. Their parents have rehabilitated themselves, and they're trying to connect with their families, including their extended families and the communities that they come from. We're just giving those parents who have done all of the things, or at least think that they have done all the things that are stated in Senator Champion's bill, an opportunity to petition the courts to see if they can make their lives whole again, I guess is the best way I would say it.
And Mr. Chair,
Senator Champion,
one thing that I would like to highlight is possibly one of the challenges has been around whether the county attorney or anyone else has filed a petition. Could be a number of different reasons. One, I took an informal survey because I practice in this area and other areas, and I asked if other people and county attorneys even knew about this provision. They said, like, no. So not too many people know about it. Number two, because of the age of 15, this means that it's possible that a young person around the age of 7 or 8 could find themselves and their family in a situation where the parents' parental rights are terminated, right? After a year, of struggling, because we really try to move to permanency. That's how we go from CHIPS to a termination of parental rights, that a child finds themselves in foster care. Now, in 2 years, it's possible, because they're a little older, because it's my understanding anecdotally that kids who are much younger have a higher chance of being adopted. But if you're in that age of 8 and you're still there, and under the current law, no one, even if they wanted to, could even bring a petition until you're 15. You're now in the system for 7 years before anyone can even bring a petition under the current law. And by that time, with all due respect, some county attorneys are not always still present, although I know there's state wars, there's reviews and other things that happen. But that's why the age issue is of concern to me as well, is because now you have that young person who has to sit there for this arbitrary, timeline, when a parent may have been suffering from opioids, gotten themselves together after some time, because it takes some time in order to deal with that dependency question. That's what professionals have constantly told me. And then when they get to the place where they can and they can demonstrate it, now they have to wait even longer. And if we only let the county attorneys make the decision, you may have a county attorney who's not interested in filing that petition for you.
Very good. Okay, do we, no, we're going to do the amendment first. So have we discussed the amendment pretty thoroughly, Senator Champion?
And the first part of the amendment is quick. It's just, I've been working with DHS and others around how do we make sure that the language around the expungement part of it, it just simply says, amongst other things, is that if a person files a petition under 609, the expungement law and other provisions, and they then go to court, and the court says, yes, I want to expunge this, then it has to be expunged, and DHS can't use an expunged record in order to deny someone a license or disqualify them. That's all it says. But if there's a separate proceeding, like for example, if there's a maltreatment proceeding that's separate from the criminal, because you can only expunge criminal records, you can't expunge administrative records, then it just simply means that that separate proceeding administratively can still be considered, but the expunged record cannot be considered at anything in that portfolio.
And Senator Champion, that's a whole separate topic from this whole other thing we talked about.
That's
Senator
a separate
Rosen.
topic. That's why I said you got kind of like two bills
called
here.
attention to it. Senator Rosen.
Well, thank you, Mr. Chair, and thank you for bringing this forward, Senator Champion. This is a very it does need adjustment. I do think, Mr. Chair, what is the path of this bill?
from here to judiciary and then the floor, I
And to the
suppose.
floor.
'Cause there's no fiscal, it might actually save some of the kids in foster care, but there's no official savings being sought or costs that are anticipated.
Thank you, Mr. Chair. I do believe this is a very important issue. I would like to see this in front of the Child Protection Task Force, too. It's an issue that should be reviewed with all the pertinent people coming to the table, too, to talk about this. And I'm not sure if we're actually the ones right here to make sure that we have this right, but I think you're onto something. I just want to make sure that we're not overreaching in some areas, too.
And Senator Rosen, officially, we are the right ones.
And Mr. Chair,
Yeah.
my commitment, Senator Rosen,
Champion.
whoever else you want me to, talk to even informally, because I always try to talk to a cross-section of people, so I'm addressing even my blind spot and try to, and I'm always committed to trying to find common ground where we can find it, but there are times when we just would differ, right? But I really like to test it because I want to make sure that there's as much balance here as humanly possible. And I'm always looking for ways to get to yes, so we all understand substantively what this means and not just from a territorial perspective. Because you'll hear people who would just say, no, because I want to do this, right? So my commitment to you is that I'm willing to keep talking to you or any other group that you'd like for me to circulate this to.
Okay, any other questions to the amendment? Senator Klein.
Mr. Chair, Senator Champion, I just wanted to also add my voice thanking you for bringing this forward. And as we hopefully become effective at treating substance abuse disorder and many of our energies and funds are directed towards that, this will be the second part that needs to be resolved. So I appreciate you being forward thinking about it and bringing this forward for us to work on.
Okay, Senator Hayden moves the A1 amendment. I don't think we moved it yet. Any questions about the A1? All in favor say aye. Aye. Opposed? Okay, so
County Attorney's Office, Mr.
I think we'll do testimony now. Yeah, so and there's two people have signed up to testify, Mr. McClellan and Ms. Ryder. So if you're both here, you can both come up. We already did. Okay, Ms. Ryder, welcome to the committee.
Yes, thank you. Good afternoon, Mr. Chair.
Welcome to the Human Services Committee. You don't probably get here a whole lot, do you? So this is pretty amazing. We're glad you're here.
Thank you. I'm Janet Ryder. I'm the Chisago County Attorney, and I'm also here today in my capacity as the chair of the Minnesota County Attorneys Association Juvenile Law Committee. The Juvenile Law Committee is a robust committee of assistant county attorneys who practice in the area of child protection, and we represent a great cross-section of all counties throughout the state. So today, I will be speaking to Section 6 of the bill related to the reestablishment of parent-child relationships. So specifically, the main portion of the bill. Last Friday at the Minnesota County Attorneys Association Juvenile Law Committee meeting, the Juvenile Law Committee had a robust conversation about this bill, and they did vote unanimously to oppose this bill as it is written and would be bringing that recommendation to the Minnesota County Attorneys Association Board of Directors. So I can, as was referenced earlier, the County Attorneys Association was at the table in 2013 when this bill for reestablishment of parent-child relationship was first introduced. And the language that's at issue here was carefully crafted to establish an opportunity that everyone at the table thought was appropriate. Essentially, the establishment of a parent-child relationship is appropriate in specific circumstances, and particularly those where a child's parental rights to their parents have been terminated and the child has been in foster care a considerable amount of time waiting adoption, and they are not likely to be adopted in the foreseeable future. So when the language was crafted for this bill to pertain to children 15 years of age and older and having been in foster care for 3 years waiting adoption, that was the group of children that we felt were at the risk of aging out of the child protection system and not having a permanent home, a permanent family to go to once they came into young adulthood. And so I wanted to note that the MCAA was at the table at that point in time and felt like this was a compromise that they could live with. in the grand scheme of things, we understand, people working in this area in child protection really understand that it takes parents a long time to overcome their mental health issues and their chemical dependency issues. But they are given a full year of concentrated efforts by the local social service agency to correct those issues. And it's state and federal law that requires us to bring permanency to children within a year, because that's what's in the best interest of children. That is state and public policy. So when we're saying that maybe cases move too quickly and parents aren't able to correct their obstacles that prevent them from parenting, it is state and federal law that is guiding us in those timelines. So in this case, we do want to talk about the three main points that I think are at issue here, and that's who may bring the petition. Previously, it was the county attorneys who would bring the petition when it was an agreement with the social service agency that it would be in the best interest of the child to reunite a child with their previous family. This was important because it was the social workers, the social service agency, who was working with this child to address the child's mental health issues, the child's developmental concerns, and are working to bring that child into a permanent home. It is the local social service agency who is keenly aware of why this child might not yet be adopted. And so it was important that the social service agency and the county attorneys in that county are the ones bringing that petition. Think of it practically. A parent whose parental rights have been terminated and they have not had custody of their child, and oftentimes minimal, almost probably no contact with that child for 2 or 3 years, how would they even bring a prima facie showing to the court to say, I know it's in the best interest of my child to be reunited with me, regardless of how much progress or the parent has made? Essentially, that parent would be expected to bring a petition about a subject that they aren't legally entitled to have information. That is why that key piece of having the social service agency and the counties bringing that petition was considered so important 6 years ago. Next question was how much time must pass from the time of the termination to bringing this petition for reestablishment of parent-child relationship. At the time, we determined it would be 3 years because we have just gone through litigation, and the court in the realm of the termination of parental rights has determined that the parent isn't able to correct those obstacles in the reasonably foreseeable future, or in the foreseeable future. They aren't able to correct those conditions. So we have a child who's here in foster care waiting for their parent to correct those conditions, and when they don't do it, we're moving to permanency, to TPR, and the court has made a determination that that parent's issues are such that in the foreseeable future, that parent isn't going to correct them. So what is foreseeable future? At the time, we determined by that statute that it would be 3 years. Then the next question was, at what age would a child be subject to a petition to reestablishment of parent-child relationship? The County Attorneys Association came to the table and brought forth the age limit of 15. And why is that? Children who are in foster care are always adoptable. They are always eligible for adoption. And we believe wholeheartedly that they are always able to find a forever home, forever family. However, at age 15, I would note that our adoption statute, after a child is 14 years of age or older, a child has to consent to that adoption. So we believe that at 15, that child could say, I don't want to be adopted, but I do want to be reunited with my family. 15 is an age where a child is old enough, mature enough to weigh in, to have some resiliency, to be brought back into a family that they were formerly removed from due to likely very serious neglect or abuse issues. 15 was an age that we determined was appropriate for that petition to come forward. So while we recognize that every situation is unique as to each child and each family, we do believe that there needs to be some serious parameters or guidelines when we're changing public policy in this realm. And that is first and foremost the best interests of the child. Our statute says that the best interests of the child are paramount. And so I would say that it is a little bit concerning that this bill and changing these parameters makes it very parent-focused rather than child-focused. And so we do want to make sure that any bill that's brought before the court any petition that's brought before the court to reestablish parental rights, that it is not going to derail a child who's likely struggling with their own mental health issues due to their trauma that they suffered earlier in life. These are really serious concerns, and so we think that paramount consideration of best interest of the child should guide all consideration in amending this bill. I know that there was some thoughts that there is no fiscal note to this. We would say that even if one petition of this nature is brought forth in Greater Minnesota, it puts a burden on the local social service agency, the smaller county attorney's offices, the bench. If a petition of this nature is brought forward, unless this local social service agency is on board and in agreement, there will be protracted litigation. It could be a trial of several days that will take up the court's time. Additionally, we would note that Minnesota Association of Minnesota Counties and MAXA should be at the table, because anytime a petition is brought forward in this realm, the local social service agency is going to be vetting the information that's set forth in this petition. They're going to be doing a full investigation. They're going to be investing a lot of additional resources even after we've already tried to reunite, and they're going to be the ones who are utilizing many more of our taxpayer dollars to see if this parent's petition is viable. And then finally, again, the guardian ad litem. Key players in all of this, they would obviously be reinitiating the investigation. They'd be reconnecting with parents' families to determine if they have, in fact, made any of these changes or corrections that they're alleging in their petition. We do believe that there's fiscal notes, and while we don't anticipate that there will be a large number of these petitions, we believe that everyone that's brought forward should be given due consideration, and that will take time and resources from the counties.
Thank you. And let me just get the testimony in, and then Senator Champion, go ahead.
If I might, two things.
I have like 14 questions of my own, so go ahead. It's your bill.
So two things. One is, if you look at page 5 of the bill, and if you look at line 5.26 and 5.27, reestablishment of the legal parent and child relationship is in the child's best interest. The child is still at the center here. There's nothing that changes that. And secondly, secondly, it is child focused. It's not just parent focused. The whole reason for asking the parent to jump over all these hoops is because we want to make sure that the child is at the center. Secondly, there are no additional resources around guardian ad litem. Not even in child protection cases is a guardian ad litem required to do any investigatory work. None. So any representation that would suggest now that the guardian ad litem is going to have to investigate something is just not the role of the guardian ad litem.
Okay,
the guardian ad
well,
litem's role.
I have questions from Senators Ralph and Hoffman, but I'd like just to get the testimony, and then we can move to that. So I'm just
So my other testifier is only talking about the expungement portion, and because that's not really your focus, I told him that he potentially would not be testifying here today because that's more.
Anyway, so alrighty. So is there any questions about the expungement part, since we have a witness about that part?
Thank you, Mr. Chair. Yes, I do. And I think I'm hearing about, I wasn't quite sure the relationship.
There's really two parts to this bill.
So they're not related?
No, there's two separate topics. One is about
two separate topics, right.
One is about child protection.
Well, that's what I wanted to be clear about, because my question had a little bit more to do with the expungement situation, but I kept reading and rereading, couldn't tell if they were related or two separate subjects. Okay.
Well, let's do the
I know you want to do the one first, of course.
So just sit there, Mr. McClellan. And so let's, Senator Ralph, then. We'll for sure by 4:20, we'll take up the expungement question, and just so we can give this thing a fair hearing. So Senator Ralph.
Thank you, Mr. Chair and Senator Champion. The statement that you made about that this really doesn't change on line 5.27, but I believe when you say on your amendment on line 3.2, you say that this clause, which I assume is referring to the reestablishment of the legal parent and child relationship, is in the best interest. must be satisfied only when the county attorney is the petitioning. So that does change the situation, because and maybe I'm interpreting this wrong, but if the parent brings the petition, then is it not still the job of the court to determine that this is in the best interest of the child? And that would be contrary to what you're saying in the bill.
So,
Senator
Mr. Chair
Champion.
and Senator Ralph, no matter who brings it, the best interest of the child is what the court has to look at. What you are referring to is what DHS and others and I talked about, because at one time I didn't have the county attorneys being able to initiate a petition, and that it would only be a parent. I brought the county attorneys back into the fold because I think that they should be able to make a decision. But I was asked to make sure that if the county attorney is going to bring a petition, that is only upon agreement between the county attorney and the county agency. So no matter who brings it, to your question, Senator, the best interest of the child is still at the center, no matter who brings it, because that is clear that this is child focused.
Senator Ralph.
All right. So I guess, Mr. Chair, I'm sorry, as long as we're clear that this is intended not to create any sort of of impression or any sort of interpretation that would in some way take away from the role of the courts. I mean, I'm very much in favor of trying to get the children back together. We need to do stuff in this area, and so thank you for bringing this. But I want to make sure that we don't upset the apple cart in terms of what actually happens downstream when we are finally in the court proceeding. The other thing that I'm
Senator Ralph, if we can maybe leave the courts part out of this. I mean, this is the human services side. We're interested in the child-centered and all that. I think if we start to parse all the judiciary stuff, you get to do that again when this bill gets there. So if you can just limit your questions to sort of the main idea of it. Do we think it's a good idea for a family to get a second bite at the apple if their life has gotten squared away and they really want to try again, even for a child who's been languishing for 2 years post-termination, and no one seems to want to adopt this individual, and they want to give a run at it? Do we think that's a good idea? That's really the question before us. And so go ahead with that in mind.
Right. And I understand that. Thank you, Mr. Chair. The other question, of course, is the guardian ad litem and their role. So just you commented that they wouldn't be doing an investigation. It would seem that that would be their job as a guardian ad litem, to represent the best interest of the child. Isn't that correct?
Mr. Chair, Senator Champion. So when someone used the term investigatory and the testifier used it in the context of going out to make sure these things are true, going out doing that, that's not the role of the guardian ad litem. Guardian ad litem will be there. All that information automatically comes into the process, and that's why this bill also provides for the guardian ad litem to be served with the petition and all the supporting documentation. The guardian ad litem's role really is to articulate the concern for the child. Like, what's the child going through? The guardian ad litem sometimes have conversations with children that no one else has, because their sole responsibility in CHIPS or in permanency is only to talk about the child. That's it. And all that information is provided to the court, and so thank you.
Senator Champion, I love it when Judiciary Committee comes to us. It's like, it's a special time. Senator Hoffman, you're on line there, Senator. Senator Hoffman.
Thank you, Mr. Chair. I can
question?
zero in on human services because you got enough attorneys sitting around this table. That was causing some smiling, and yet at the same time, people were feeling uncomfortable. You know, I want to focus on the word the, and then I think we should, rationalize the meaning of the. Senator Ralph, I'm only kidding. So that was a lawyer joke, but all sincerity.
That was funny.
It was funny, but it's not. I love where Senator Champion is going with this, and he completely said it. I've heard 18 times the best interest of the child, right? And so when you talk about the human services reality, the child and the family in the construct of McKnight's theory and Dr. Carl Dunst, those guys, it's always the child and the family is the center point. And beginning in this case, so I like how the methodology is going and the tone of that. But I think that says more about how those social services agencies are going to be responsive. And I believe in the best practice, in the best interest of the child, they're going to look at the reunification of the child and the family as a whole. I like where this is going. I'm a little concerned when I hear an attorney say, we are driven, an attorney, not one of you guys, but an attorney here that said, it's the state and federal law that guides us, which causes a question for me that says, are you in the best interest of the child or are you in the best interest to uphold the law? It's more of a question. And in this case, I'm all good on Senator Champion's bill because he's looking at the best interest of the child, not necessarily upholding some state or federal law that somebody else created. So we are opening up a new approach here that says we believe the family. We want to believe in reunification of the family. I think the human service interest is huge in that, and I think we move this on and let it go to the judiciary and let them discover what the word "the" means. So I thank you, Senator Champion, for bringing the child and the family together in the conversation. I think it was well done.
Thank you. Senator Klein.
Mr. Chair, and testifier Ms. Ryder, so we heard anecdotal reports that people have experienced zero petitions made by county attorneys for reunification of parent and child. Does that match with your experience? And doesn't that seem a little surprising? And I admit that I'm not working in your world, and maybe that seems entirely appropriate to you. But can you explain that to me as an outsider?
Ms. Ryder.
Mr. Chair, Senator Klein, in the group of the Minnesota County Attorneys Association Juvenile Law Committee, we were not aware of a petition that was brought forward for reestablishment of parent-child relationship in the 6 years that this bill has been in effect, or the previous bill had been in effect. It is not surprising to me in that the instances where a family is able and willing to come forward and ask the local social service agency to say, I would like to have the county petition to have my parent-child relationship reestablished, is a burden, and it could be intimidating. I understand that. But the factors that need to be in place for that to occur are really unique in that the parents' health, mental health, chemical dependency health, their ability to provide for the physical and emotional needs of the child are quite significant. And at this stage of the game, the children's needs are often quite significant. So practically speaking, I'm not surprised that there haven't been more. I am surprised by the testimony that people weren't aware of this provision. I think that of anybody practicing in this area should have been aware of it. I believe parents' attorneys, whether it's the public defenders in Hennepin County or court-appointed counsel who practice in greater Minnesota, it's my belief that they as practitioners should be aware of this and have that available to their clients. Aside from why that is not happening, I can't say. But truly, the factors need to be in line for a petition to come forward.
And so maybe that's a hint that the law didn't really work. So just my thinking. Senator Hayden.
Thank you, Mr. Chair. And I was going to ask the similar question of Senator Klein about the reasons why no one has ever come forward, but he beat me to the punch. I guess what I would try to say and maybe impress upon our friends that are county attorneys is, one, there's the elephant in the room here. There's also a disproportionality of kids of color and African-American kids in the system, period. I have a bill that hopefully we'll hear that's going to address this comprehensively. So there is that. There is an inordinate amount of kids that are in, that's the data point, that's in the system that look like that. Those kids are kids that don't get adopted. Those kids are the ones that graduate to the streets, and then those kids we end up seeing in our social service network and our MFIT program, or they see it down the block in the Judiciary Committee and Community Corrections and all of the work that we have to do there. So that's kind of the path that we're operating on. Secondly, I guess what I would say is the work that we're doing in this committee, specifically, Mr. Chair, around substance use disorders and all of the 245G, I guess, work that we're doing to really take a good look at behavioral services, mental health, substance abuse disorders. We bring people coming here from Teen Challenge and other very reputable chemical health organizations, and they let us know that it takes a little bit of time to get yourself together once that has clicked in your head, that substance use has been turned on, regardless to what the substance that they're addicted to. And so, but they also tell us that there's hope that we can get our lives together if you follow the path, if you do the things that you're supposed to do. But that usually works outside of a year. So and Senator Abler kind of hit on it. I appreciate you following the law. That's your job. That's what you were sworn to do. But the law may not be right, or the law might need to be adjusted. There also, in a practical sense, is a lot of things that we ask people to do while they're also getting themselves together. They must, at the same time that they're in treatment, find a suitable place for the children to live. I think that makes sense. They need to take care of all of the other things that they need to do for you or for the social service organizations to feel comfortable for them to do it. There's a huge burden that gets put on people in a short amount of time in which to do so. And then, per the law, you move forward for TPR, and judge grants it, and now the parent has lost the rights to the child, and the child has now lost his rights to his family, his extended family, his cultural community, his church, or whatever the case may be. So I think that it is reasonable in the case that a child has not been adopted, is not in a permanency track, for someone, the parent, to say, you know what, I got myself together, I went through the chemical health organization, I did all the things I'm supposed to do, I'm back on track, I'm back in school, I'm working, I got a place to live. I might even had a couple of children since then. I got other children, and I'd really like to reunite my child, and I want to petition the court to see if that would be okay based on these factors. If that's a little bit of a burden on the court, if that's a burden on the local social service agency, that's a burden I'd like to see. I'd like them to take on, because the burden and the cost for us not to do it, and for that child to stay in the system, for us to have for them not to thrive, for us to then see them for a very long time in our systems, I think that cost is astronomical, and we don't do the dynamic scoring around here. We're not there yet. We're not sophisticated enough to figure that out, but we all anecdotally talk about it. So I respect you guys' approach to doing this work and saying this is why we've done it. What I think you should review is how we're doing it, and is your practice in line with what we're saying on the other side of the dais? Is the county attorney and the law, is that practice in line with chemical dependency or substance abuse disorder rehabilitation? And they feel like, and they don't seem like they're aligned, and therefore just a very narrow way of looking at this is allowing children to stay or without any opportunity other than the county attorney who is not coming forward to do the work. We're allowing children to stay in a system that has very poor outcomes for them, and they aren't doing very well.
Senator, we'll just, we're almost to move along with this segment, but Senator Hayden, I couldn't agree more with what you said, and I actually share your concerns, and I'm actually going to add myself onto the bill as a co-author. I think I was on the other one anyway, so. So I want to move into the other part, but, well, I mean, we could discuss this for an hour. So, Senator Benson, go ahead.
Mr. Chair, and yes, the best interests of the child have to be primary, and I apologize, I stepped into the back, but so are the county attorneys saying that there is a significantly increased risk to the well-being of a population of children if we move this bill forward?
Ms. Ryder.
Our position is that science shows that children do better developmentally and socially if they have a safe, stable, permanent environment. And while parents struggle with chemical dependency and that treatment might take a long time, we see every day success stories where people do engage in services, do come clean, do get their children returned to them. Those cases are success stories. We believe in treatment. We believe that it works. And for those children, they are reunited, and that is the most positive outcome. For those cases where children don't have permanency, child development requires them to have a safe, stable, permanent environment. Oftentimes in these cases, I would submit, I don't have statistics or data specifically, but what we know about child development, that even a safe, stable foster home can be as good for the child's mental and emotional development as having that possibility of more upheaval and more change coming forward in their life. And so while it might be appropriate for some children, I would say that for the best outcomes, safe, stable foster care is very positive for children.
And just, I want to offer a comment, and then we're going to move to the other part like I promised. Ms. Ryder, I just wanted to help. I feel like you're going to be helping to derail this bill, and I don't blame you. It's your job to, let me just finish, please. But there's some blind spots, I think, that you have that I wanted to try to tell you in a kind way. I've been here 20 years. I know how things go. I know what groups are, and your group decides. We made a thing 6 years ago. No one's using it. But what about the kid who was put into, whose parents totally, there's a subset of children that this is attempting to address, a small handful. And it's a child who is in foster care somewhere. It's been 2 years now since their parents were terminated with all that challenge. The parents definitely got their attention and they're trying to get squared away. And the only thing they have left to do is wait till he's 15, which that's the group that Senator Champion is trying to get after. And so they're not stable. They're in this stranger's home, and they've been kind, and they do all the things together. They go on vacations, but it's not their family. It may not even be the same culture, the same neighborhood. They've lost all the family they don't see anymore. What if that family that you said, and you mentioned they wouldn't know who the child is. Well, what if they begin to re-engage, and they come around, and it's going well, and they're there every week, every month, or regular times, and they even agree with the foster parents to go with them on a trip, and it's going famously. There's no avenue for that 10-year-old kid's family to try. That's what we're after here. And I have to move it along. But I wanted to encourage you to think about the groups. And I think that, and I know a lot of county's attorney, whatever you are, but you're dedicated to your work. You're always under pressure. You make the wrong decision, you're in the paper, and I get that. But there's some kids here who need a chance to have another chance. And there is some disproportionality, I think, and especially when you get into the system in the beginning, you have someone helps you with a borrowed lawyer, and you're scared, and you're in a bad spot, and you don't have the resources that somebody else might. And so I just hope that as this goes forward, that you and it's just a comment, but I don't have time to let you respond. Well, I'll let you respond. Go ahead. I talked to you, so go ahead. Yeah.
Mr. Chair, the first opportunity we had to talk with the bill's author was yesterday. We had some discussion. There are some points that we think that there might be some movement. The question might be, we will keep an open mind. I understand that there's a small section of children for whom this bill might change their outcome. I think that we agree and acknowledge that every child and every family unit is different. We acknowledge that in some instances where children are in foster care with relatives, they might have some ongoing contact with that biological parent whose rights have been terminated. I'm not saying that this is a done deal, but I do say that as this bill is written, we did object to it. We don't approve of it. And to the extent that we can come together and find a little bit more of a common ground, we are open to those discussions.
I'm really grateful about that. So thank you. So we're going to move thank you, and I appreciate you coming forward. You can still stay. Senator Kiffmeyer, you had a question about the expungement part. Are you familiar with the situation that drives this particular section?
Yes, I am, Mr. Chair.
Okay,
I'm just
so go
waiting
ahead, ask
to
your
have.
question. Yeah,
No, I just want to have an explanation first.
Oh, please, yeah.
Of the presenter of the bill, Senator Champion.
Yes.
And his testifier before I ask any question.
Okay, so if you could do like the 1 minute and the 1 minute,
Briefly.
that's all it needs,
Yes.
I think.
So this particular section is just saying that under 609A, which is the expungement statute, is that if DHS has been served with the petition, notified of the court appearance, they can weigh into that court appearance. And once the court makes a decision about a particular criminal case, if the court orders an expungement of that case, is this, that DHS is also subject to that order, which they know, that they can't use that case or the facts of that case as a basis for denying someone license or that sort of thing. Now, the difference is there are criminal cases and then there are administrative law cases. And so this policy still says if there's a separate proceeding like maltreatment proceeding and the same facts from the criminal case are also appropriate here, is that DHS then still can use the information gathered from the administrative law proceeding as a part of their decision-making process, because those are two separate proceedings, and you cannot expunge an administrative law record, but you can expunge a criminal law record. That is what it gets to, and I also have someone from DHS if you have some specific questions. So in the amendment, they gave me some technical advice, and we just wanted to make sure that that information is clarified.
Senator Kiffmeyer.
Mr. Chair, I do understand it. I read the bill, and I read exactly what it said, right? Okay, so that wasn't the thing. The question for me is, so who opposes this? And is there someone here who supports it? And I'd like to hear from them and why they support. I can guess, I can figure, but we're here in a committee hearing, and I want to hear what others think, and especially if somebody has traveled here and sat here for this long a time, you ought to at least be able to say a few words.
Is there anybody who'd like to speak in opposition to this?
There's no one in opposition that I know of.
I'm just asking, so. Okay, and so Mr. McClellan, welcome to the committee.
Hello, my name is Jonathan McClellan, and I would like to thank this committee for giving me an opportunity to share with you today. I would also like to thank Senator Champion for presenting this bill. In 2008, the Collateral Sanctions Report was issued to the legislature. This was the product of the Collateral Sanctions Committee created and fully funded by the Minnesota legislature in 2007. In that report, it stated that the legislature should carefully restrict the number of convictions that will trigger absolute bars from particular kinds of employment or eliminate such bars entirely. The committee received compelling accounts of people who were unmistakably rehabilitated, who gained valuable insight from their experience, and who could not use that understanding constructively because they are absolutely barred from working with the people whom they could do the most good. This report goes on to state that exceptions should be made for exceptional people, and those who have obviously turned away from wrongdoing ought to be able to put their crimes behind them. In 1974, the Minnesota legislature declared that it is the policy of the state of Minnesota to encourage and contribute to the rehabilitation of criminal offenders and to assist them in the resumption of the responsibilities of citizenship, the opportunity to secure employment or to pursue, practice, or engage in a meaningful and profitable trade, occupation, vocation, profession, or business is essential to the rehabilitation and the resumption of the responsibilities of citizenship. This report indicated that 3 decades later, now 4, we have experienced the difficulties of setting rehabilitation as a goal for policy. The question becomes, how does this impact our communities? Here's how it's impacted my life. In the mid-1990s, I was a young homeless high school student in Ramsey County who pled guilty to a crime that permanently barred me from working in the healthcare field. I found this out after I successfully completed an EMT program at Hennepin Technical College. The final part of that program required me to pass a background check so that I could do my clinicals. I was informed at that time that I would be removed from the program because I was unable to clear a background check from DHS. I convinced the director of the school to keep me in the program until the situation was resolved. I went to the licensing authority called the EMSRB board, who regulates EMTs, and I was told to fill out an application for consideration and fill out an application for a background study. And a hearing was scheduled for me to present my case. I was called back into the hearing, and after a unanimous vote, I was granted permission to proceed. The MSRB found an ambulance service that was not affiliated with a hospital requiring licensing by DHS to do my clinicals and finish my requirement for school. I successfully finished my coursework and clinicals, and my license was granted. As part of maintaining my license, I had to be working in the EMS field. I got a job working for CART Ambulance, and that allowed me to transfer patients between hospitals. After I was hired with CART Ambulance, 3 days later, I was told that I did not pass my background check and I was going to be let go. I pleaded for my job back and was told that the ambulance services hands were tied and I could no longer work there. But if something changed, I would be allowed to return. At this time, I applied for an expungement with the court, and the expungement was granted by the Chief Judge of Ramsey County. I then found an ambulance service in Belle Plaine not affiliated with the hospital that would allow me to volunteer. The ambulance service was taken over by Alina, and we were told that we would have to apply and go through the hiring process again. Around this time, the Minneapolis Fire Department was hiring, and I submitted an application. Out of close to 3,800 applicants, my final ranking was number 24, based on my test results. The personnel chief of the department called me and informed me that I would have to write a letter explaining what was on my background check, and it would need to be reviewed and approved. The Minneapolis Fire Department eventually got back to me and let me know that I would be able to continue the process. This process consisted of medical testing, college, fire academy, and intensive psychological evaluation. I would eventually earn the coveted title of firefighter. Several years after I was hired, the state passed a law requiring all firefighters to be licensed. In order to be licensed, I would have to submit to another background check and a Q&A by the board as to my background. My application was unanimously approved by the firefighter board, and I was granted my firefighter license. A few years after this, I was injured in the line of duty saving a young man's life, and I was not able to return to the work that I love because of my injuries. Despite having thousands of successful patient contacts, I wanted to go back to the root of this issue and fight for people who are similarly situated. As a family man with 4 kids ages 7 to 19 years old, I have tried to teach them the importance of fighting for what they believe in. For almost 15 years, I've worked to change this policy. I am passionate about meaningful criminal justice reform in our state and operate behind the scenes where policy is crafted. I have served on the Human Rights Commission for both Bloomington and Richfield. I have also run for public office. I have graduated with honors from community college in business with continued studies in fire science, hazmat, arts and investigations, legal writing and research. And I graduated with my BA from Metropolitan State University magna cum laude with a focus on community leadership management and pre-law. I will continue to do my part as an engaged citizen to make sure that the scales are balanced on social issues and reforms that impact families and marginalized communities. Thank you.
Senator Kiffmeyer. Thank you. And the reason I wanted to hear that was not because I had any notes ahead of time of what you were going to say, but because I feel that when someone has come, I want to hear that. Also, though, however, by virtue of another issue, I came across Minnesota statute, which says that when somebody has completely fulfilled their time, their probation and such, they are to be treated as if they had never committed the crime. That is current Minnesota law. That is current Minnesota law. And I think it is time that we recognize that when you have done that, and it says should be restored to all rights, but as if they had never been convicted. Now, I was busy listening and paying attention. I have the citation of that law up in my office in a file folder so that I can get that for you, but I just thought it was really important. I wanted to bring that out because I think that's current state law. I don't know when it was put in place. I think it is good state law. I think it fulfills the sense that if you have committed a crime, you paid for it, and when you're done, you're done. And then you should be in that situation. We have Minnesota state law that already says so. With that, obviously, I do support this. But I thought it was really important to hear you, but I also wanted to take the opportunity to make reference on the public record of that Minnesota state law, and I can give the citation later.
Thanks. And Senator Kiffmeyer, the point of this niche bill is even beyond that, when you're expunged, it should mean something. That's kind of the point of this, and it's unfortunate that that's the trap this young man found himself in. Senator Kiffmeyer, did you want to say something? You're done?
Yes.
Okay.
Mr. Chair, were you looking at me?
Yeah, did you?
No, I was done. I just.
Okay. Thanks. You have 20 seconds to not screw it up, then we're going to take your vote.
I have 20 seconds to wrap it up. Thank you to everyone. Mr. Chair, thank you for allowing me to have this time before the committee. Committee, thank you for being so engaging. Thank you for having an open mind. I will continue to work with the other interested parties in order to make sure that we can try to craft something that we all can be proud of. But I hope that we will all be able to get there because there are children who are in foster care and parents who need our support to bring their families back together because they can demonstrate that it's in the best interest of the children. So thank you.
Thank you, Senator, and thank you, Mr. McClellan, Ms. Ryder. I appreciate the dialogue, and thank you for your good attention. Senator Hayden renews his motion that Senate File 342 as amended be recommended to pass and be referred to the Committee on Judiciary. Everybody understand that? All in favor say aye. 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 Opposed? Thank you, Senator Champion, and with that, we are adjourned.
Thank you, Chair.
About to decline.